Good afternoon, Mr. Drama. My name is Caleb Finch. I am one of the founding members of MCMC Law, a director within the company, and a practicing solicitor. Now, unfortunately, MCMC Law specializes in cybersecurity law, so we're unable to offer assistance regarding the matters arising out of the execution of your parents' will. Although as we're a new company and still establishing ourselves, we'd be more than welcome to take you on under a retainer, just for the matters arising out of the transferring of the shares. Before I continue, however, there's still numerous preliminary matters to discuss and agree upon before we can enter into a retainer for our services. These are predominantly related to issues surrounding the costs, consent, determining who I'm actually representing in this matter, and whether there are legitimate contracts and agreements between all the parties in this matter, namely being your sister and your wife. So having said all that, initially I want to discuss who I'd be representing in this matter. This needs to be absolutely clear before I can discuss entering into a legal retainer with you, so I'd like to remove as much ambiguity as I possibly can. If I understand you correctly, Mr. Drama, what you're asking is that you would like to transfer money to us for the use of transferring shares from your sister to your wife. Just from an initial observation of this, it appears as though you wish us to represent your wife in this matter. However, given your other requests of asking us to attempting to obtain the will from the law firm in possession, then executing the will, transferring the ownership of the shares and property in which the business operates, in addition with you also being the one wishing to pay our bill, it appears as though you wish us to represent yourself, Mr. Drama. If this is the case, and we are to be representing you, as I will assume is the case, then we require authority from your wife and sister that this is how we are to be acting, and that this is actually what they want. It's not that we believe you to be lying. This is simply just a legal requirement to ensure we're acting in the best interest and not in violation of any laws. This can be done by us receiving written confirmation from both your wife and sister that this is their intention. This can easily be done by both of them receiving some independent legal advice, so they're fully aware about what they are asking and signing, so that they can give some informed consent. Now, I understand with your sister's disability, this may be a bit difficult, especially if your parents were her carers before they passed, and there's been no real official transfer of care to you. This would be a matter that needs addressing likely before any real progress can be made. Unfortunately, this will cost some extra money on top of the already required fees, which I'll get into in a moment. I also understand that you are concerned with the costs and whether or not they're actually a legitimate cost. In this instance, we're required by law to charge costs for certain things, effectively. This is all regulated by the Legal Profession Act 2007 Queensland and the Uniform Civil Procedure Rules 1999 Queensland. If you wish to confirm yourself, I can send through the sections stating this in an email later if you'd prefer. Digressing, however, this is something that will need to be done, and any ethical and lawful lawyer will tell you the same. Also, before entering into a retainer, we at MCMC Law must ensure that there's not going to be any conflicts of interest involving acting with you as our client. Now, I have done some preliminary research into whether any current employees at MCMC Law have been involved in any matters related to any of the parties regarding any of the matters you would like us to act for you on. Currently, no one in our employ has been involved in any such matters, and that there's no arising conflicts from these. Although, as MCMC Law is recently established, we're a recently established company, we're still hiring new employees. So it is a policy of ours that any new employee is checked against our records to ensure there's no relation to any parties in any current matter, just to try and avoid all possible conflicts. If there is a new hire who might pose an issue to confidentiality, I can assure you this individual will not be involved in the matter. What this effectively means is that we can act in your best interest, and you have no reason to be concerned otherwise. So next, now just moving on to talk about costs. There are some very specific aspects of costs that under Australian law I have to disclose to you. Unfortunately, as you're overseas, I cannot provide the cost agreement documents or retainer documents physically as we normally would MCMC law as required by the law. I will be forwarding these documents via email, and we can talk again if you're still unavailable in person and have any questions. It's my understanding that you wish to employ us under a client retainer, just to act for you on a number of matters. To properly encompass this, I will need to have a cost agreement drawn up that does encompass all the matters that you wish us to represent you in. This will be one of the documents that I'll send via email. Attached will also be a list of disclosures I'm required to make regarding the costs and how those work out. I will get onto this in just a moment as well. In the retainer, I will limit the scope to the matters that you have asked for assistance on. It is fundamental that we're on the same page regarding this, just to ensure that MCMC law and I do not act in any way you do not wish us to. So moving on to what I'm required to disclose before you can retain our services. Our legal fees are calculated on an hourly basis with a scale of costs applying if any of the matters go before the courts. You have the right to negotiate a cost agreement with us and request an itemized bill after we've receipted you for the lump sum bill. Whether you request this or not, you'll still receive a bill from MCMC law. At this stage, early preliminary stage, we estimate that the legal costs for this retainer will be between $5,000 and $15,000. I am aware this is a large range, however, due to a lot of uncertainty with the time requirements to contact your wife and sister and have those contracts drawn up and how long it will take for them to receive independent legal advice, and then especially considering any capacity issues your sister may have. This will increase the time it takes for all this work to be done, and therefore it subsequently increases the cost. I must stress that this is an estimate, and it could quite possibly be more or even less than the $5,000 to $15,000 range. Now, you'll only be billed upon completion of the retainer. Then there's no interest for any overdue fees. You have the right to request progress reports on the work. You have the right to dispute a cost agreement and potentially have the court set it aside if the court has deemed that the agreement is not fair or reasonable. This all falls under the Queensland court jurisdiction. And yeah, fundamentally, you also have the right to enter into the cost agreement if you do choose. We will also notify you immediately if anything changes and more disclosures need to be made. You may contact me again if you have any questions about legal costs. Yeah, these documents, these disclosures are all set out and explained more thoroughly in the documents I'll send via email. This is just a sort of brief overview of what those will all say. So those were all the main preliminary issues surrounding entering into a retainer with MCMC law. I believe I've detailed enough information for you to make an informed decision about whether or not you would like to enter into a retainer with us. If you have any questions regarding anything I've said, please feel free to ask. As I said before, it is essential that we're on the same page regarding the retainer and how you wish us to ask, just so we're not overstepping any boundaries or doing anything you wouldn't like us to. Now, onto the money you wish to transfer to us for the shares. My understanding is that you wish to deposit the money with us on behalf of your wife. If this is the case, you will immediately be issued a trust receipt as you are the person transferring the money. If I'm incorrect here, however, and it is your wife who will be transferring the money, the receipt will be drawn up for her. If this is the case, this will still go into your file, however. We are required to take specific details upon receiving the money, as per Queensland law. These details predominantly revolve around who deposited the money, why it was deposited, and where it was deposited from. So as you wish to do a bank transfer, that is an acceptable method. We will note these details in our trust ledger and receipt book within 5 days of receiving the money. And just so you're aware, these details will be kept for a minimum of 7 years. The details of the receipt will be given will include the date the money was received and the amount of money, the form in which the money was received, in this case it would be a bank transfer, the name of the person who deposited the money being either you or your wife, a detailed description of the matter, effectively a long version saying this is for the acquisition of shares, and a reference number given to the matter, the name of our company, MCMC Law, and the name of the employee who created the receipt for you, as well as the receipt's number. Further, as the money for the shares would be classified as transit money, we will not need to deposit this into our trust account, but the details I mentioned before are still required so we can keep detailed records about the money. We will only hold this money until, at the latest, the date you request. This may be, however, longer than the 3 weeks you initially asked for, as due to the matters I mentioned previously relating to obtaining consent from your wife and sister about their intentions. This may take, this could potentially take a significant period of time. Now, I'd like to thank you, Mr. Drummer, for contacting us here at MCMC Law. I will be forwarding all the documentation I stated earlier in this email after this video has gone through. I encourage you to contact us again, sorry, if you have any questions, and if you would wish to confirm whether or not you will be taking us on retainer. And once again, I would like to thank you from all of us here at MCMC Law, and hope you have a wonderful day.